Hi guys, it's Kathy. I hope you're doing well. All right, so poor Judge Fleischer had to leave early today because his son was sick. But I mean, he did a lot before he left. Don't worry, we're good. But first, we're going to go into a courtroom, I believe in Connecticut, and this inmate has an uphill battle. I don't even know.
The judge again addresses this, stating, and this is in Exhibit B of the state's motion on page 12, that you felt there were phone records or some evidence of a Google search. The state indicated to you evidence of the Google search was not done. There was no evidence. There was evidence of a phone search, and that was turned over.
So this Google search we're going to hear the whole time. So the inmate is saying the trial was wrong. Everything was wrong because he didn't get discovery. Of course, he had a couple lawyers while the trial was going on. So he's trying to get his case overturned. I believe that this case started in 2021, what he's in for now. While I'm playing this, I'm going to look it up, and because we're going to want to see what happened, if there is anything.
In fact, I think Mr. Franklin did two things. One, he indicated on the record that he had let his investigator look at it. And number two, we stopped the trial and let Mr. Franklin speak to Mr. Lorenzen to make sure there were no issues. I want to make sure that you understand and that the reviewing court understands that your claims were not ignored. Just to clarify, Your Honor, I believe the defense switched Mr. Daniels switched defense attorneys during the course of this. So the judge was so concerned that he stopped the trial, let the current attorney speak with the prior attorney, just confirm that there was that there was nothing there, or this search that he said. He did indicate that there was a phone search done at the time. So this Google search, this document that or search that he claims was there, it exists. This was litigated. This was discussed. Defense had an opportunity to cross-examine, to dig deeper, to address it legally in the first or in the underlying criminal case. And as to the
just real quick, here's the complaint. Now, it's not his fault. He's in jail. I mean, he doesn't have a computer to work on. But here's the complaint that he submitted. He's saying that there's new evidence. This was in July of 2021. All right, he's saying that, there's new evidence in this. So he was convicted of assault, of a bad assault. And they couldn't even give him lined paper. I'm not reading it. I'm not beeping anything. No, I'm just showing. He tried to look up different cases. Every time I heard a pro se say exculpatory and the police, I already know that yeah. So this was what was started in 2021. So that's what he's trying now. He's trying to overturn this. I think he has a lot of years. I'm not sure. I'm sure they'll say in here, but I think it's like 30 years. I could be wrong, but I don't think so. So he's trying his best.
Text messages, any claim regarding those, the record in the underlying trial indicates that the defendant refused to turn over his phone. This is set forth in Exhibit C, pages 10 through 13. That he wouldn't turn it over as part of the investigation, and that there were no text messages between Mr. Daniels and the victim on her phone, which was turned over and was examined. Your Honor, the state submits that in this case, the record is clear, that there is no newly discovered evidence. Everything that Mr. Daniels is raising now as newly discovered was known about, was litigated, he was given an opportunity to confront it or address it in the underlying trial. There are no new issues of material fact in this case because there is no newly discovered evidence, and that the respondent, we believe, is entitled to summary judgment as a matter of law. We would ask that the court grant our motion. Thank you.
Thank you, counsel. Mr. Dunbar? I'm sorry, Mr. Daniels.
Okay, Your Honor.
Yeah, I'm sorry.
There is multiple issues with what was just brought forward. It's clear from the record that I requested the evidence in the trial, and during the sentencing, I was representing myself, and I requested it again. And multiple times, it was said that it does not exist. In fact, Judge Dodabo made it clear, and the defendant's exhibits, page 8, line 27 through page 9, line 1. He asked the state's attorney, Bakikio, that was on the presiding case, he stated, "Let me ask you this. Do you have anything in your files that shows anything about the Google search?" Anthony Bakikio, the state's attorney, responded no, that there was nothing in his files of a Google search. If there's nothing in the state's attorney's files of a Google search, then there's no way that my attorney could have had it. We requested it multiple times, and he made it clear to the court that there is no Google search, and that he turned over incoming and outgoing phone calls. That alone shows that the evidence that is being requested is clearly a Brady violation. He says he doesn't have it, but the police department did confirm, and it's that this evidence was turned over to the state's attorney's office. We have other issues where I requested it once again for the summary judgment, and I can't see how we could even proceed in summary judgment when I requested from the state multiple times this evidence, a copy of it, because I don't have it, still don't have it from the trial. They never had it during the trial at all. And she responded to the court's, the Judge Sheridan. Judge Sheridan told her, actually instructed Attorney Cox to turn it over to me on 5/8/23. The same date, she sent a letter to me saying that she did not feel that I was entitled to it, although the judge clearly stated that she had to give it to me. So we're still having a discovery issue. I can't see how we could proceed with a summary judgment when we still have a discovery issue. The other issue is that there are multiple claims in the petition that are left unargued. She's filing, the state requested that we proceed with, at the state's request, we went back to the original petition. The amended petition was withdrawn. So she filed a summary judgment on an amended petition that were not, it was at the request of the state, it was already it was withdrawn. And I agreed with it. So we went back to the original petition, which alleges more facts. So there's a lot of facts that were undisputed. She didn't comply with discovery. And it is clear from everything in the record that multiple times, actually, she stated herself in her summary judgment that the evidence that is the newly discovered evidence was exhaustively addressed. So to say that it was exhaustively addressed and it was never turned over, then I can't see how you could say that my due diligence wasn't there. The highest form of the only way that I could get this from you is from the state's attorney's office, and if a court orders it. If a prosecutor tells the judge that it doesn't exist, how could he order you to turn something over to me? So it was addressed, but it wasn't turned over. It's a Brady violation, and this court actually has the jurisdiction to see that. Thank you.
Thank you. Thank you, Mr. Daniels. Attorney Cox, response?
Your Honor, we did have that meeting last year. I guess there are two issues. One is the state turned over everything it had in the underlying criminal trial. What I have of the transcripts there, we have turned everything over.
Okay, stop there. Just stop there. You have turned everything over. Stop.
There is nothing else for us to turn over. His attorneys have all of the evidence, have everything that was needed in that underlying case. So there's nothing more that the state could turn over. Additionally, I did review the file, and there was nothing to turn over. Also, I mean, this is Mr. Daniels' motion for a petition for a new trial. I don't understand why it's on the state to produce his newly discovered evidence. He should, I mean, the burden would be on him to demonstrate that there is newly discovered evidence. I don't understand why it's the state's responsibility. We had turned everything over to Attorney Franklin and Attorney Lorenzen in the underlying trial.
Okay, so Mr. Daniels just referred to an order by Judge Sheridan that I'm trying to find. It was, look, I think you said, Mr. Daniels, May 8th, 2023.
Yes, he said in the I believe I provided the transcripts. He said in the transcripts that he did not, he didn't, damn, I don't have it. Oh, shoot, sorry. He said in the transcripts, he said that he didn't need to do an order because he instructed her to turn it over. And literally the same day that he did that, she sent a letter to me saying that she wouldn't. I provided the letter on it's a May 19th motion for order of compliance, but it was never heard. But I know it's the letter is there. There's a letter from Attorney O'Connell saying that she would turn it over, and then there's a letter from Attorney Cox saying that she would not. And if you don't mind, I would like to answer to that. We're looking for a Google search that the state said that they did not have during the trial. I provided evidence to the state and to the court that there is a Google search because the police department gave me affidavits, which has been provided in discovery to them, that it does exist, but they wouldn't turn it over. They turned over portions of the Google search where I could see the searches that was done that is beneficial to.
I found the letter. He was just talking about, saying that she says, "Dear Mr. Daniels, as discussed in this afternoon's status conference, I was recently assigned to this matter. Upon review of your discovery request, I do not believe you are entitled to the entire state file in the underlying matter. The state file was provided to your counsel during litigation of that matter. Should you disagree, you should file a motion with the court." Well, guys, guess what? He filed a motion with the court. He's right. Whoa, calm down there, buddy.
To me to show that this case shouldn't have even went. It's to show that she Googled a lot of things that she shouldn't have been Googling if this was a true case.
I Google a lot of things I shouldn't be Googling.
They said that it never existed. In fact, he's in court saying that he did not have it. And I provided also audio transcripts of an FOI hearing where the police department said that they did turn over the Google search to the state and that they deny any withholding on their part. So the evidence of the Google search, there's no doubt that it's there. It's an issue of I'm trying to get it in its entirety, but the police department said I couldn't get it without an order. So I attempted to get it through the prosecutor's office, who's still saying they don't have it, which if they don't have it, they couldn't have given it to my attorney. Once again, proves that it's newly discovered evidence.
All right, Attorney Cox.
Your Honor, I did speak with Attorney Bakikio, who handled the underlying matter. What Mr. Daniels is referring to is allegations that the victim had Googled his name prior to reporting the sexual assault. And when they searched her phone, they did, we turned over everything that we had at the time. So the state had already turned over everything. Like, there was nothing more for us to turn over to Mr. Daniels. That was what was addressed at the underlying trial, the search that he was talking about, and that the court was made aware of it at the time, that's what he was referring to. His defense had an opportunity to cross-examine or follow up with police or anybody regarding that issue at the time. So the contents of this alleged search, was made known at the time of the trial, that was what he was referring to. And his counsel had ample opportunity to question or cross-examine anyone on that. That was the allegations that he was making. The state doesn't have anything else to turn over. we absolutely did, Attorney Bakikio did not withhold discovery, which is what Mr. Daniels is alleging in the underlying case.
And what is this Judge Sheridan order? Are you familiar with what Mr. Daniels is referring to?
That we turn over what we had as respects to this Google search, and there's nothing else to turn over. The state hasn't discovered any new evidence since the time of this trial in 2018, so there's nothing new for the state to turn over.
Okay, so let me just try to make sure I understand just quickly, and then you can. I will definitely read all of the exhibits that have been submitted in the briefs, but so there, Mr. Daniels indicated that the police had indicated to him that there had been a Google search. Is that correct, Mr. Daniels?
Yes, and actually,
Okay.
if you don't mind, I would, in the defendant's exhibit, A, page 7, and lines 6 through 9, Anthony Bakikio stated he spoke to the officers about what are in the phone records, and there was no indication of any of that, referring to the Google search. So if it wasn't, it's not that we had it or they gave it to us. He said there was nothing in his files of a Google search for him to give to us. Once again, the police department has confirmed that it is there. And I provided the state with evidence that they saying that they turned it over to him. I don't know whose issue it is of whether the police gave it to him or not, but under Brady, it doesn't matter. If the police had it in their possession, it falls on the prosecutor.
All right, so where do you submit the police affidavit for me to review? Where is that in your filings?
It is. Oh, man.
I don't think that's true, right? Okay, so the prosecutor has to turn over everything it has, but if the prosecutor doesn't have to go find other stuff for the defendant if it's there. So if they didn't use the whatever the police had, this Google search that the police had, if they never got it, if they didn't use it, they don't have to go find it for him. He has to find it himself. He has to talk to the police department himself, right?
Give me 1 second.
Yeah.
I believe it is Exhibit F from on the plaintiff's Exhibit F.
And so let me just inquire, because Judge Sheridan's order does not reflect anything in this case about Attorney Cox having to turn something over. But I think you both agreed that Judge Sheridan indicated to Attorney Cox that she should turn over anything that she had to Mr. Daniels. So Attorney Cox is indicating she had nothing to turn over because everything had already been turned over. Is that correct?
That's correct, Your Honor.
Okay. And Mr. Daniels, I just want to make sure I understand what Attorney Cox's position is. Mr. Daniels, your position is Attorney Cox told you that she did not have to turn it over.
Yes, it's I provided on a May 20. I just had it 20. I provided it. It's in. I filed for a motion for order to compel, and that was on 5/19/23. It should be in there on 5/19/23. There's 2 letters. There's one where Attorney O'Connell said that she would contact the detective and get it if she doesn't have it in her files. And then there's one where Attorney Cox says she's not going to turn it over. She doesn't feel I'm entitled.
Okay. And so Attorney Cox, is it your position that your office obviously is turned over everything that your office had, and that was adjudicated in front of the trial judge, the criminal trial judge? But how do you respond to Mr. Daniels' claim that the police indicated that there was something, that there had been some Google searches.
I believe that Attorney O'Connell had reached out. We got no new information from the detectives, and that anything we had related to any sort of search was adjudicated in the underlying criminal trial. And at that time, the content of what Mr. Daniels alleged was in that Google search, which was that the victim at the time had Googled his name prior to calling the police. And for what it's worth, I mean, this was a contemporaneous report. This was, she didn't wait days or weeks before reporting the sexual assault, was that she had Googled it. The content of what she believed had happened came out in the trial. There was opportunity to cross-examine on the content of that. The victim herself did testify at trial. So what he's alleging was even in the contents of that search was available to be cross-examined or questioned on in the underlying trial. And as to, I think at the time when we met and had pre-tried this case in May of 2023, the state's response was that we didn't have any more to give him, and that, at this point the state wasn't going to turn over its entire file, because that's not what the basis of this newly discovered evidence is on the petition of the new trial.
Okay. And let me just quickly address, because we only have a couple of minutes left. Let me quickly address Mr. Daniels. You indicated that there were 2 petitions filed. One, the original, and then there have
Peg, like, you have to come in here every single day because we have lots of questions.
been an amended, I guess, complaint, and the amended complaint had been withdrawn. And so now the operative complaint is the original complaint?
Yes.
Okay, and that would be 9/21/21?
Yes.
Okay. And is it your argument that there are allegations in that original complaint that have not been addressed during this motion for summary judgment?
Yes.
Right. And Attorney Cox, any response to that?
I mean, Your Honor, the state would take onus on that. I am probably the second or third attorney on this case. I didn't realize in my review of it all that the amended complaint had been withdrawn. So if you need anything supplemental as respects to the original complaint, I would be happy to provide that. I didn't realize that the amended complaint had been withdrawn.
Your Honor, I'd like to object to that because Attorney O'Connell is still on the matter, and she's the one that requested that it be withdrawn. So I don't believe that there should be it should have been communication amongst them about this matter.
Okay. All right. I will definitely take a look at the complaint. I will take a look at the motion for summary judgment and exhibits, the opposition and exhibits. I will also look at the motion to compel May 19th, 2023, just with respect to Judge Sheridan's order. Anything else that either party believes is relevant to this motion here today?
Not from the state, Your Honor.
All right, thank you. Mr. Daniels?
No, Your Honor.
Okay, thank you. I will issue a decision.
Thank you.
Thank you.
Court stands in recess.
Thanks.
Okay, here's another one. This case is another one. This, I showed you like 2 days ago. Was it 2 days ago? 4 days ago? I showed you days ago a case where even the trial that was on that day wasn't listed, wasn't shown here, and here it is again. So when I wanted to grab this, I read through this docket and to see what I liked, all right? And then I read through the complaints and everything, and I looked at some of the documents that are in here, and then I looked down here to see when the hearing was, if it was a hearing or if it was just, a motion setting or whatever. And it was a hearing. And that's not even here anymore. And the last thing they have in here is from 7/18. Well, this was after 7/18. This was like 7/29, I believe, or 7/30. It was like just like 2 days ago or 3 days ago. What happened here during this thing, it doesn't even show up. It's just not here. I thought maybe it was attached to one of the older so like the result of this was done on this day, and I looked through it all and I could not find, anything. I couldn't. It's just not. It's just what we just saw is just not in the case at all. Now, I'm sure it'll be there. I'm sure it'll get there, but the last thing on this list is from May. And the next thing on this list in December is the pretrial conference, and then January is the trial on this. So I don't know. I'm kind of wishing him. Do you not hear me? I'm wishing him good luck. I'm hoping that he does well. Okay. So we're just okay. What I normally do is I take Judge Fleischer's docket and I cut it in half, and then I show you guys half, which is about an hour or more. And then I save the rest. Well, unfortunately, poor guy today. Yes. Unfortunately, today, his son got sick and he left. So he had, thank you, pre-trial. He had to go. So I'm just going to show you his whole docket today, which is more than an hour. So that's why I'm starting his docket early. Can you hear the words that are coming out of my mouth? Okay.
So let me give you a phone number. We spoke to a guy yesterday by the name of Cedric, right? And they have, it's called the Los
Angeles house.
Yeah. Good morning, Mr. Bueno. We're going to try to find you a house for.
I need a house. No, I don't have a house, but guys, this is going to be rough for everybody because you know who's not in court today? Victoria took the day off. And let me just tell you, Victoria took the day off, but she was in Judge Fleischer's chat the whole time, and it was freaking hilarious. She was hilarious. Poor Melissa, though, had a day. And Victoria kept like announcing violations in the courtroom as they were happening. Victoria's like, you're not supposed to do that. You're not supposed to. Arraignments first. Arraignments first. So she's going to have a nice little team meeting when she gets back.
Somewhere for you to go. First, though, the first thing we need to do is we have to do something called a TRAS. That's an evaluation to see what kind of services you may need. Okay, please be honest.
I was talking to a lady yesterday. I can't read, but I got her number, her name, it's a paper. And my brother had talked to her. My brother's trying to talk to her right now, trying to get in touch with her. And he's gonna give her the money to go. She wants a group home. And
we're working on finding you a group home. We had a gentleman in here yesterday who found a home that was willing to keep him. And what I'm going to do is I'm going to reach out to them to see if they will take you as well. Okay?
Okay.
But first things first.
I wanted to go to that lady group home in Missouri City.
Say that again.
I'm going to go to a lady group home in Missouri City. She charged $600 and I got the money tomorrow. I get a check every month. I get it done later.
Well, let's do this first. Save your money. I'm going to try to get it to you for free so you don't have to spend money. Okay?
No, I wanted to go to her house because she sounded really nice and stuff, and she said
Will you give the number to Alan so he can verify
I
that?
called her twice and I did leave a voicemail. I haven't received a call back yet.
she said just leave her a voicemail and she was gonna get back in touch with him.
Well, let's see if she gets back in touch with Alan. If she does, then I'm okay with it as well.
Okay.
But first things first, we're going to send you, can you mind sketching us a TRAS for Mr. Bueno and in custody ASAP? How long do you think it'll take?
So.
Do you know?
Email them and I'll let them know that I do
Okay.
it. So right now it's going to be starting. But I'll let them know. that-
August 12th for in custody too?
But I'll email them, let you know, or let them know.
Or if you want, I mean, I can reach out to them too. Perhaps we can kind of see if there's any kind little pressures. I don't know.
Usually
know?
I email them and say that the judge is listening.
Yeah, will you please? And then before we reset this, Alan, let's see how far of a date she gives.
Thank you, Your
When you go, be honest, okay? Just be honest with all the questions they ask you, because if not, it's not going to be any help.
I really wanted to go to Lady Group home. I got her number.
Yeah, we'll get you there. We will get you there one way or the other. But first things, we want to have you evaluated to see.
Because my buddy's about to give her the money tomorrow.
Okay, I'm with you, Mr. Bueno. We will get you into the house. But first, get this evaluation done. I'm going to try to get it to you as quick as possible.
What violation is it?
Say it again. What do you say?
What kind of violation is it talking about?
To see what other services you may need other than just housing.
I don't need housing. I just need a group home.
But you also take medication, correct?
Yeah, she gives us medication. She said she's gonna take me to a psychiatrist. The lady.
This is who I'm having you talk to.
We're gonna.
That's who I'm having you talk to now.
Here for free.
I don't want it for free. I got Medicaid. I can pay for my own doctors. I got United Healthcare. I don't want nothing free. I just want to go to the group home where I can pay money.
First, I want you to do the TRAS, then we'll get you to the group home. Okay?
What's a T-Rex?
I'll have Alan explain it to you. Okay?
I'm gonna check into back there, okay?
I gotta go back to custody.
Just until the TRAS is done. After that is done, we're going to get you out into a group home. Okay? I promise you I'm working with you.
I want to go to Miss Daisy. Daisy. I got her number, her name.
Okay, we'll work it with you.
I'm gonna
Okay?
call it again and see if we can arrange something, okay?
Mr. Bueno, everybody here is trying to help you out.
Yeah.
Okay?
We got you,
They're
Mr.
gonna get
Bueno.
you
We're
where
going to
they
take
need
care of
to
you.
go to and where you want to go, they're going to help you. All right?
Okay.
Come on back this way and Alan will be able to talk to you better.
And just let me know what you find. Look, I got this note from Victoria.
What does it say?
Sorry.
Do arraignments first.
I just wanted to offer both. I mean, we
Victoria said do arraignments first, and he didn't. He didn't. But no, so I'm in this chat every day. All right. But I have it on mute because I'm grabbing videos. So I have this on mute and I'm just watching the chat. So I'm seeing this for the first time with you guys. And I didn't even realize that it started off like that. I thought it was bad. I thought the way the chat was going, I thought we were going to start off. I think they even said, wow, we're starting off with a bang. So that was really good. That was, we saw him before, right? I'm positive we had him before. And, oh, I can't remember. I'm going to have to find it and I'm going to find it and link it to the last time we saw him.
He did offer time serve. We even wrote it up, but he last minute said he didn't want it. So
It's okay. Great. I think this is even better. I mean, so we stop picking
I
cases
give him
up.
both options. So when the TRAS suggests something, like this is one option. this
I'm
is
not
the
going to
other.
take TRAS.
I think it was trespassing.
I'm not going to take a time serve so that we can fix or help resolve the issue. So, I mean, we're working what? 15 cases now? No, it stops.
Thank you, Your Honor.
Okay, thanks, Alan.
Antonio Arrington.
Yeah. Come up, Mr. Arrington. I think they spelled your name wrong, unless it's really like that. Is it Antonio Arrington or how do I?
Antonio, but like it's been
Is there an extra?
on my ID since birth, and I never just they spell it.
So the way they spelled it like this, it's correct.
That's how it is on my ID, but it's not correct.
Antonio is how it's. I have. It can't be right.
No, it ain't right. It ain't right.
You want me to keep it like that? Mr. Arrington, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Your Honor. On July 24th, 2024, the defendant and the complaining witness were having a verbal argument over the defendant checking in the complainant's phone. And he saw that she was texting other guys. The complainant and the defendant were pushing and yelling at each other. The complainant is the defendant's girlfriend.
Okay.
Complainant stated that she never.
Not anymore.
Complainant stated that he never hit her and she didn't hit him. Witness, however, stated that she heard a female yelling for help, and the witness saw the defendant punching the CW and choking her. Both the defendant and the complainant were in the car with the door open, so so the witness could see what was happening. The complainant was trying to get out, and the defendant was pulling her into the car. Officers observed a scratch on the complainant's right arm, no other injuries. The complainant was not being very cooperative.
Victoria, they did not do arraignments first. I'm telling on all of them. I'm telling on the judge. They did not do arraignments first. They showed your note to the camera and then did their own thing.
Do we know if she wants to have contact with him or no? Don't.
Your Honor, it doesn't look like the root call has been completed by DVD.
Okay. Mr. Arrington.
Yeah, complainant did tell back that he did not assault her and that nothing happened.
Okay, Mr. Arrington, I'm going to find that there's probable cause to go forward with your case. A protective order was issued in this case on the 25th of this month. I suggest that you get to know it. If you do something to violate the protective order, the state can and will file a violation of a protective order against you. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can hold you at no bond, and I will do it in a second to protect every person of Harris County. Do you understand? I am ordering you until I know that she wants to have contact with you. I'm ordering you as a condition of your bond not to have any contact with her and not to be in possession of any weapons. Do you understand? How old are you, sir? You're 30. What do you do for a living?
Do work at Papa John's.
Doing what?
I work at Papa John's. Right, I drive box trucks. My bro got a business. And,
so how much money do you make a month, would you say?
It's hard to say.
What'd you say? 11 teens?
Hey, you ever take it's hard to say right now. You know, I'm still new to Texas, so I'm trying to figure everything out. I'm from the city.
Okay, so we're going to reset your case to give you time to hire a lawyer then.
You not speak?
No, not about the case. I've got a bunch of DAs here. Everything that you say, they're going to sit there, they're going to write it down, and they're going to use it against you to prove guilt. I'm trying to protect you from yourself, you know. Now,
he is in a prison uniform. It's Papa John's.
I know you want to fight the case. Just now's not the time to do it. You'll get the opportunity, but you need a lawyer to do it. You're facing a lot of time. Not only that, you know, a conviction like this, you get an affirmative finding of family violence, meaning that you pick up another one, you'll be facing up to 10 years in prison, and you can never own a gun or ammunition. So there are serious, serious consequences. So that's what I'm saying. You need a lawyer to represent you. We'll reset your case to give you time to hire a lawyer. I'm going to have you go to Ramona, sign a reset. After that, I'll have you go to the jury box while we get your bond conditions. We'll have you sign it. Then after that, you'll be free to go. While you're on bond, do not pick up any new cases. Be nice. Otherwise, there's only one place you're going to go. Do you understand, sir? Come on. Do you mind? Yeah, state conditions, yeah. Do you mind filing no contact and no weapons? Yeah. Great.
Carrie Smith.
Yes.
Judge, page 18 here.
Okay.
It's rare we see Pavel reading the probable cause. You know what I mean? I don't I don't know why he's up there. He's usually in the back making noise.
Good morning, Lily.
I cannot.
Thank you.
Good morning, Ms. Smith. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
So Judge, on July 24th, 2024, officers responded to a minor accident call for service in Harris County, Texas. Upon arrival, officers observed the vehicle resting in a ditch. Officer then saw the defendant exit the vehicle from the driver's seat and was the sole occupant. Officers observed the defendant to have strong odor of alcoholic beverage, watery bloodshot eyes, and slurred speech. SFSCs were conducted, 6 out of 6 HGN, walk and turn. The defendant refused to participate due to physical disability, and one leg stand was 3 out of 4. DIC red, consented to breath, 0.279, 0.270. The defendant stated she consumed 2 alcoholic beverages commonly known as Rumple Mints. Her first DWI was back in 2002, convicted 2003.
Commonly known as Rumplements. It's Rumplements. That was lovely. We've had people try to read the affidavit and stutter and make it hard to understand. He did a very good job. Thank you.
Texas driver license. Have you seen?
Let me double check.
Ms. Smith, I am going to find that there's probable cause to go forward with the case. At a 2-7, that would normally put everyone on the floor. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you continue to consume alcohol, I will put you in jail. If you continue to consume alcohol even when you're out, I will put you in a rehab facility. And it's a 9-month program if you respond to treatment well. Do you understand?
Yes, sir.
No alcohol means no alcohol from any source. No cakes, candies, foods, gums, tequila, lollipops, motor oil,
beer,
hair dye. I've heard it all. Do you understand, man?
She's eligible. Her last suspension was the ALR.
Do you have valid liability insurance in your name?
Yes.
I am ordering you as a condition of your bond not to drive any vehicle that it's not equipped with an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock on it, likewise, you will go to jail, and I will take your privilege to drive permanently away from you. Do you understand? How old are you, man?
42.
What do you do for a living?
I am unemployed at the moment. I watch my niece and I do random odd jobs.
Like what? How do you support
burglary.
yourself? You need money in life.
I watch my niece. I get paid for that. And I am helping my mom start her LLC. And I get paid for that sometimes as well.
Okay. Did you want to apply for an appointed lawyer, ma'am?
Yes.
Okay. I will give you an application. We'll have you fill it out. I will take a look at it. I need to know everything about you, what kind of car you drive, how many cars you have, stocks, bonds, mutual funds, IRAs, and then I'll take a look at it. And if you qualify, which you probably will, I'll appoint you a lawyer today. Okay, man? But I'm serious when I mean no alcohol. Understand this. You got out of jail because we gave you a free bond. If we put your bond at $5,000 to $10,000 and you don't have anyone to pony up the money, what happens? You'll be stuck like Chuck, right?
Yes, sir.
Consider that when you're out there. Okay. I'll have you go there. We'll give you an application. I will have you go to Ramona, sign a reset, and then we'll have you take your sit in the jury box while we find your lawyer.
Ramona, I love you. I love you, Ramona. Shout out to Mary Beth, but we're going to have you go to Ramona and get a reset. Ow. Ow.
Yes.
Jim?
Hey, good morning.
How are you?
What's new, man?
Same old, same old.
I feel your pain.
Nothing's changed much in 30 years, Judge.
Well, you look good for 30 years.
I have David Palomino on your docket, Judge. It's a racing case. Gavin Ellis has the case because the person my client was allegedly racing was an off-duty police officer, so it's with public integrity. But we spoke yesterday.
So did they charge the other person as well?
Yes, they did.
They did? Okay.
We spoke yesterday and we spoke. We've been texting back and forth about an amicable resolution, so I think it'll end up a PTI type deal.
Okay. So what happened with the off-duty officer? Did he get in trouble? Did he get reprimanded?
They've charged him and public integrity has it. I don't know what's gonna happen with it.
I mean, because we need officers, right? We hope that probably, well, I don't know. So it's only 130 days old. It's not too terribly old, but it's getting up there. We'll give you 30 days. Have you guys relayed the offer yet, or has Gavin
No,
relayed
Judge,
it?
the only reason why is, Gavin, he got called out to an officer involved shooting, so he's not here today. That's why I was working on this case. I can't relate any officers on this case, so.
Right.
Sounds like they're reaching a resolution.
Yeah.
Okay. I guess you want 30 days. What do you want?
We should have it worked out before.
Yeah. Okay. All right. For sure. Thanks. Top of 13, Palomino. Just a normal reset, and it's still waived. Do we have any more arraignments? No? That's it for arraignments? Any THAs?
Yes, that was
Hey, Chris.
Hey, good morning, Judge.
Morning.
I have 2 cases under docket, Your Honor. The first one is Caden Slack.
Is that with an S?
With an S, yes, Your Honor.
I get paid every day.
Okay.
Judge, we're going the PTI route on this one. Right now, we're in the process of putting together the packet. He's a 0.18.
So he'll need a mitigation packet then?
Correct, Judge.
Okay. It's 160 days. So we'll give you just a couple more weeks, and he's got to be here at the next setting so we can send him for a TRAS.
Okay. Understood, Your Honor. And then the other one is
like
just
2 to 3 weeks. Okay.
Okay.
And then let me talk with
hi,
Ramona to
Chris.
get your date. And who's your second
Okay.
guy?
And the other one is Jessica Smith. Same deal, Your Honor, except we don't need a mitigation packet for this one.
Okay. That one I can give you a little bit longer because it's only 136 days. So we can give you a full 30 day on that one.
Okay.
Just bear
I
with me a
love your
second, then
boss,
I'll get your
CJ.
date.
Okay. Thank you, Judge.
Well, if you want to help Brian first, well, please. Bottom of page 17, Slack. So 2 to 3 weeks, getting a mitigation packet done, and then they're going to appear here to get a TRS done. We'll walk through.
So it's 21st, August 21st.
August 21st-ish.
That works, Your Honor.
Is the 21st a good date for you?
It's a good day, Judge.
Okay.
The police made me do
And
it.
then the top of the next page, top of 18, just a normal reset.
On that one, what's gonna happen? What are they doing?
They're also doing, yeah, well, no, but just a normal application on that one. But they can have a full reset.
What are they doing?
PTI. They're going to apply for PTI. But they don't need a mitigation on that one.
Okay. Did he want the same day or do you want?
No, longer.
I do birthday shout outs, but not to Ben or Phil.
Do you want the same day or do you want longer, Chris?
Oh, if we can get longer, Judge.
September 11th.
September 11th?
Can we do the 10th, please?
Sure. Okay, it's yours.
Thank you, Judge. Maybe excuse.
Okay, man, have fun. Yeah.
Your Honor, you too.
Hey.
Morning, Judge.
Hi, Mr. Mercer.
Ashley Durant.
Okay. she here?
She is, Judge.
What are we doing with Ms. Grant?
So she's been kicked out of DWI PTI.
Okay.
Repeated positive.
Oh, that's right. She didn't make it here last time.
Yes, sir.
Okay.
Which was my fault, because I didn't.
Yeah, that's right. We're not dinging her. Otherwise, right, she'd be in custody. So we just need to know, what did she do? Didn't she do? And state, are you okay with keeping her on or no? I guess that's.
Yeah, I judge no, for Nathan, she's out.
She's out. Okay, sorry. Come up, Ms. Grant.
Yes, sir. We have, officer in the office.
Yep, she need to make that decision today.
Yes, sir.
Ms. Grant, come on up. You know, one day you're going to look back on today and you're going to kick yourself 15 times. Why did they make this thing work? Such an idiot. It's just, and I'm sorry, it's not my decision whether to keep you on or not. It's not my program. It's the DA's program. But they require strict compliance. And when you don't, there are consequences. So that is, now we need to decide what you want to do. So I will have you talk with Mr. Mercer. You must accept either today the plea bargain from the state, or otherwise we will set your case for trial. Okay, please. And then you tell me.
I think we got a decision already, Judge. We already spoke about it.
Okay, what do you want to do?
Time served.
Okay, have you written it up yet?
I'm doing that right now.
Okay, so if you just want to take the seat back over there, we'll have Michael explain to you all the paperwork while you sign it, and we'll get it done and get back. Okay?
Thank you, Judge.
For sure. Logan, this is a probation case that we're having. It's an admonishment. You're doing good. You're getting there. Don't miss any classes. You've got 6 done. You've got, 12 more to do, right? This is the way that you get this thing dismissed. As I was telling the other gentleman, this kind of case, if you end up with a conviction, has really, really serious consequences. All you have to do is show up for 12 weeks and then it's gold. Do you understand? Don't you miss one. It's all over. We're going to set you off 30 days and I want you to come back for one more compliance check just to make sure that you're doing well. And then we'll set you off further if you're in compliance. Okay? All right, man, go ahead, take a seat. We'll be back with you here momentarily. Eddie Mendoza. Is it?
Not really. No, not if I'm care.
Right. You have been on probation since August of last year, and you have done nothing.
I actually have signed up for classes, sir. I don't know if that shows yet. I've been taking a couple already.
I don't care about signing up. I don't care that you sign up because we tell you to come here to court and that's what causes you to get things done. I don't think so. Take your seat for me in the jury box.
These minor sins. So what are we doing? What the courthouse. So she's a 7
I got called into work early. I don't know if anyone noticed, but not yesterday, but the day before, someone left Judge Fleischer's chat mad for religious reasons.
You ready?
Yes, sir.
Come on, right on up.
Miss Grant, you will forever in a day remember this because, you know, the problem is that this conviction will go on your record. It will be there for the rest of your life. You can never, ever take it off. You must also understand that from now on, you'll be facing a minimum of 30 days in jail for any cases that you pick up, don't matter what it is. If you ever get pulled over and an officer, run your plates, because that's the first thing they do. They want to know who they're dealing with. The first thing they do is they will look at your criminal history. They're forever will see that you have a DWI in your record. If they roll up to your window, if they smell alcohol, if they smell marijuana, they smell anything funky, what do you think is going to happen? Right? Don't give them a reason. I would never, even if you've had half of a beer, because to me, it seems like you like to drink. If you're going to do it, because Logan, how many?
I believe it was 46 over the course of 2 or 3 months.
46 blows of positive over the course of 2 months. That tells me that you like to drink. If you're going to do it at home, wonderful. Don't get into a car. What we're doing today will not happen again. Do you understand? You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. You understand? How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to 3 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 180 days. Do not drive until you get a license. I'm telling you, if you get in a car and drive, it's a Class B misdemeanor, just like a DWI. You will be right back in here. And it's not going to go well for you if we see you back in here. Okay, good luck, man. I'll roll her court costs so she won't owe anything, because she's probably paid quite a bit for the program. But I'm telling you now, I will have absolutely no sympathy if you come back here with a new DWI. That tells me you have learned nothing. And what we do to little children who don't learn, we punish them somehow. And what we do, just like a child, will put you over our knee, spank you with a ton of jail time, just like a child. All right, good luck. Thanks, Mr. President. Hey.
Good morning, Judge. How are you?
Come on
May
in.
we approach?
Yes, ma'am.
What's going on?
You said last name was,
On Marcus Perez.
okay.
But I was just going to introduce you to my dear friend Sachi.
Hi, nice to
Sachi
meet
is
you.
going into her senior year of high school, and
Oh,
she's
nice.
good in law school. So she's kind of
Wonderful.
checking out the courthouse this week.
It's fun. And it's,
Several judges have told her to run fast and far. They're all telling her, run.
what? Why? The judge
Why?
is telling you this? Hell, no, don't listen to that. No, there's no better profession than being a lawyer. You learn so much information, it's sick. And the thing is that no one can take advantage of you. No one can take advantage of you in this life if you know things. And you know things by going to law school, because they teach you just a crazy amount of just abstract information that you would never even think about, like uniform commercial code. You know, there's this one theory in the law called adverse possession, where if you take a piece of property and make it like your own for a prescribed time, you can basically take it from someone underneath them. Yeah, it's crazy. Just so many things that you learn
Homework,
just
guys.
from going to law school.
Homework.
Even if you don't become a lawyer.
what she has learned down here this week. She said the most thing she's learned is that people are really weird. Very weird.
Well, I mean, where are we?
It's true.
No?
It is true. She may have also been talking about some of the attorneys in my office, but I mean, it's fine. It's fine.
It makes for an interesting time. Right?
It has been very.
It's a fun gig. And when you're a lawyer, if you treat the profession well, it'll pay you back in dividends. I mean, it'll pay you like God. Right. So
she's interested in international law. So
well, I don't know anything about international
she's going to do
law.
well.
I don't know. I can't tell you anything about that. I don't know what kind of money they make. I don't know how interesting it is. It's probably just all contract work. You sit there and read at a desk all day. I don't know.
Leave her alone.
But you don't try cases like what we do.
Yeah, this has been fun.
It's fun.
It's a special kind of person, really. It does, but it's fun. I would say yes. Do it.
Do it.
Thank
See,
you.
I think you're the first
Don't
person
listen to
tell
anyone
her
else.
that.
Thank you.
Oh.
Thank you.
Is he the first one to say do it? I feel like everyone has said.
Yeah, everyone's been a little.
I can't believe that.
Yeah.
I really can't. This is it's the greatest job in the world. You can, I'm telling you, if you treat it well, you can make so much money. I had a friend that made $350 million a couple months ago on a judgment.
Me too.
Wow.
And then a month later, he makes another 60 million.
Yeah.
Really. So I'm telling you, if you treat it well, if you study hard, if you do your research, it'll pay you. It really will. Not like us in criminal.
Yeah.
Still fun, really.
It is. It is.
Ask her. She does whatever.
Vince, let's do this. I'm going to sue you from Pennsylvania. You're in Chicago, right? And we'll fight about a pencil. All right. We'll say that I have your pencil and I'll say that no, it's my pencil, and we'll see how far we can get in court. We'll see if we can push it 4 years. Anything. But yeah, breakfast tacos is lovely. Yes. But anything is lovely, really. Get her some food on the way home. Hey, why weren't you at work yesterday, Michael? I had to delete 2 messages. Someone said something really bad about Judge Stevens yesterday, and bunnies hopping in the woods all in one sentence. All right, see if we can see how high we can take it, because it is cross state lines. All right, we're gonna start a lawsuit about this pencil, and we're gonna see how high we can take it. Let's see if we can go to the Supreme Court about our pencil.
Whatever she wants to do. Kim does whatever she wants to do. She don't want to work. She don't want to work. She's not going to go.
I only get yelled at sometimes. So see?
I would. Awesome.
Thank you.
Bye. Thank you.
Chris, thank you
Hi.
so
Ellen.
much. Thank you.
That's for Bueno. I've just got notified that they can do it tomorrow.
Wonderful. Great.
Like Friday or Monday.
Now that's a good question, because we get the TRAS done quick. Results, that's another question, right?
Results would be done by Friday, so I would say maybe Monday.
Really? You think of that quick?
I would think it, since it's expedited.
Great. Okay. Yeah, set it for Monday. And then, wait, did I give you Cedric's phone number?
No.
Can I give that to you? Do you mind reaching out to him? You know what? I emailed him yesterday before we left here. I wonder if he replied. Victoria, do you know if he replied? I CC'd you on the email too.
Judge Victoria has off today. Just because she's in chat does not mean you can speak to her.
Let's see. No. Today's what, Wednesday? Right? Okay, you ready? Let me just give you this phone number. This is his cell phone, okay? 713-702-1574. His name is Cedric Taylor, works for the Los Angeles, or no, he works for TLC Wellness, right? But perhaps he knows how and if we can get Mr. Bueno into this housing place.
I'll reach out today, yeah.
We tried to call, Logan and I tried to call this housing complex yesterday and like the number wasn't working. I don't know, but he replied and so.
I did try to call the number you gave me multiple times. I haven't got anything. But I'll reset him for Monday. And
does he know who that was? What was the name again?
her name was Diane and she
Do
said.
you have a last name?
Just
If you can get a last name, then I can try to look it up.
okay.
I could put it in the global list and try to look it up.
And the last thing, since my dad was in the army, about he stopped screaming. He cooks in every single day to watch.
Right?
Yeah. So
Who's screaming? Me?
no, my dad always been asking lately, he's not streaming no more. Why is he streaming?
Who?
My dad. He watches every single day.
Right?
Every single day. But since he stopped, he's just been.
Well, tell your dad that you do an excellent job. That we love you, you know?
Thank you.
For sure. Yeah, hopefully. Yeah.
Judge,
Hey, Ricardo.
on a client, Mr. Guillermo Morales Duran.
In custody on bond.
He's on bond, Judge. Now, I needed to approach because you put a condition that he needed to be educated. And so I was trying to get a reset on this case.
What is Mr. Morales doing now?
Well, he, as far as education or working?
Both.
Well, working, he works at a nice restaurant called El Jardín. It's where Mamacitas first started, I believe. They're related to the Mamacitas chain. And so he works there. He's been trying to.
This is the gentleman who's our age who can't read or write.
I believe so, yes.
What is he doing?
So he's gone to different locations. I told him to go to a location called AMA. It's a Hispanic organization where they help the Latin community with needs. The first time he went there, they said, hey, we only got classes for kids. So then they put him in touch with the consulate's office. He went over to the consulate's office. They said they sent him somewhere else to Baker Ripley in his neighborhood. He went to Baker Ripley. They said, hey, we don't do that. We just do employment. So he went back to AMA. They sent him back to AMA. And so he talked to somebody different there. And so there's a class that he could go to, but the class that's current is already in session. So they can't put him in there. The next availability is until September 9th. He's struggling with finding the transportation to figure all this out. And he's got limited means to do it
I'm gonna
online.
reach out to someone now.
Okay.
So bear with me a second. I have other things to do.
Yes, Judge. The only thing I was going to say was he's got a plan in place. Hama is kind of just a metro trip down because he lives in the area, sort of. It just takes one trip from metro to get down there. So it's a viable solution if you allow him to wait till September 9th. It's a great organization. And
Okay, I'm gonna also reach out to the MAC to see what other things that we have, other resources that they may have perhaps, and they can also help pay to try to help them, learn how to read and write.
There's a lot of stuff online, Judge. The problem is he can't afford it and he's not.
That's what I'm saying. I'm gonna see if I can pay for it.
Okay.
Right? So just bear with me. I just need a bit of
I'll
time.
come back on that one. Okay, I'll do that.
Is that it?
Just for the regular docket, yes.
Okay. Okay.
Appreciate it.
Paria,
Morning, Judge. How are you?
hey, what's up?
Not much. I'm here on Chandra Moss. I approached on her last week. I can't remember if it was Thursday or Friday. It was the fugitive who you agreed to give a bond to, but you wanted her to be here in person. We tried to set her on docket for Monday, but I don't know what happened. There was some sort of glitch and she didn't make it on the docket. Oh, are Day and Amy there? I can't see them, or am I just?
No, they're not here yet.
Oh, they're not here. Well, then let me
No.
wait. Let me email them and wait till they get there. Then, Judge. Sorry about that.
I'll text Day now.
Okay, thanks. Oh, but is Garza there? Here, Deputy Garza, were you able to bring her up or no?
I have not got her up here. I'm calling the pod to see if I can get her up here.
Okay. Yeah, so they didn't bring her up, and that's what I was gonna say, because Amy and Day have been emailing me about that. So
Yeah,
I
Amy-
know that you wanted her up to admonish her, so I'm hoping they can bring her up, but if not, I'm gonna beg you to set a bond anyway, because I talk to her mom like every day. It's not like they're not gonna know what to do.
I'm gonna try to get her here.
Sounds good. I'll hang tight. Thanks.
For sure.
Who is it, Judge?
You said Moss? Did she say?
Yes, Chandra Moss, Judge. MOSS.
Mr. Fleming.
Good morning, Your Honor.
Hey.
Have Melvin Morales Soto on docket today. Need to approach just because the age of the case, and maybe, I think it's under Morales. Melvin is in the audience.
Thanks. Yeah, it's what we're doing.
So we have everything signed as far as the PTI contract. He needed a little bit more time to get the DAP and stuff. He's been out of work from the storm and other things, trying to catch up on bills and such. So he needs more time to get the payment for that and the device.
Where is he?
Yes, sir. Come this way.
Does he have the interlock?
No, he doesn't have that yet.
It's Morales Soto. Tell me, when can you have the rest of these?
Derek,
I can have it by next month, by the 15th. That's my next free check. I just haven't been working because of the.
Hey, that's about 2 weeks from now. I'm willing to give you that, but your case is 190 days old. Should happen a long time ago. I will not give you any more time after that. Do you understand? I will acquiesce to you now. I'm giving you what you want, but you will be out of time after that. Do you understand?
And that includes the.
You need the interlock. You also have to pay the DA fee, correct? Yeah. If you have any issues, go to, there are other providers around here that can either put you on a payment plan or you tell them that you're indigent and then they can reduce the fees, but it's your responsibility to find them. You must have this done within the next reset. All right? Okay.
Thank you, Ron. That's all I have today. Maybe excuse, you just take a seat.
You know what? I'm gonna call.
Good luck.
Let me call, JPC.
I'm gonna call you. What do I do?
I make good luck tomorrow.
Hey, you got a second? Can I give you cause number? 0721.
Oh, yeah, a little. He's on.
So Mr. Herndon and I have a long history, and we tried a case, I want to say about 6, maybe 7 months ago. And we set him for sentencing, and he never showed up. I ended up sentencing him anyways, and he's been just MIA for the last, since we sentenced him. They finally picked him up because he picked up a new case, another trespass case. It looks like the magistrate has given him a PR bond on the new trespass case, but I want to make sure that they don't release him because I need to sentence him on the trial case. Yeah. And I'm hoping that they don't release him. Okay. Yeah. Hey, recall the GOD, please. On Herndon, they gave him a general order bond. On the new case, recall that. And then, I guess I'll just. And then I'll just, that he's just a flight risk, I guess. We just can't get him to show us, No. Yeah, hey. Okay, I guess we'll do that. I want to make sure that this happens before he gets, if and when he gets released, because I don't know if they're going to release him. Okay, so that means that they're going to keep it. He can postpone. It says no bond. Right? I mean, I'm showing that there's no bond set. No. What happened was he appealed. So we went to trial. He lost. I sentenced him and he filed an appeal. He never did anything with the appeal. We sent him mail. We sent him certified mail. We sent him emails. We sent just about every medium you can imagine that we called him. We sent him every meeting that we could.
Smoke
He
signal.
never responded to anything. So we ended up having a hearing. That he has failed to request any kind of record, reporter's record, clerk's record, anything. And so the appeal was basically denied and it was over with. But so now what's left to do though is sentence him on the original trial so that he can do the time. I have Steve in my bailiff trying to locate him to see if we can try to get him.
A little bit.
I think Sean, I keep on being this.
How long is it going to take for him to get stressed out? And how No, yesterday. He's been in for at least 24 hours because we spoke about this yesterday. And maybe that's why they gave him a week. The sheriff's office couldn't get to him, or the magistrate couldn't get to him. There's just too many damn people getting arrested. Okay. Okay, great. Thanks, Sylvia. You're the best. Okay. I have
Clark Kent.
administration trying to locate him.
I have them also.
Because, huh? She's telling me that they're not going to send him up until they house him and dress him down.
Are you gonna?
Hey, your mom's here. Back there, okay? She might be calling. Oh. Is that your brother?
It's my little brother. It's not the one involved with the case.
It's not the one involved. Okay. That's that.
Mom, come on. Hey, Dan.
What in the world does that even mean? He needs housed and dressing down. It doesn't make sense. I don't understand.
Hi. Thank you for coming. Do you know why he's in custody? For what? Cocaine. And it's not the first time. I have repeatedly ordered him not to use, especially a 17-year-old kid. Or 19, is it 19? The only way I can protect him from himself, you are your worst enemy, your own worst enemy, Mr. Garcia. And the only way that I can control to ensure that you're not using is to keep you locked up. You can lie to me, but you can't lie to yourself. And I'm going to tell you that I don't take it lightly when you lie to me, because that tells me you think I'm stupid. That's what I think. When you lie to me, I say, this guy must think I'm stupid. And I'm not. I may look stupid,
Thank
but I'm
you,
not.
Chris.
And
Thank
I
you.
am now, will not fall for this again. Fool me once, shame on you. Fool me twice, shame on me. And you've already done that to me multiple times. So, Mom, I don't know where to go from here, because if I release him, I know what's going to happen. And was he living with you at home?
He was in my cousin's house due to the fact that he's going to be in the house because my other son is in the
Is that because of this case?
Yes, because
Okay.
This was because I don't remember anything
Before
about
this
the case.
assault case, he was living with you?
yes.
Okay.
I don't know. I don't know where to go. I don't know how to. How old is your other son that was involved in this case? He's 20. What does he do? He lives with you currently, but he currently lives with you now. What do you think, Greg? What do we do?
Well, I don't know, Judge. I mean, obviously, I'm going to ask for a bond now.
He has a bond set.
Well, a lower bond. Because the bond, from what I remember, is pretty high.
15,002.
Right.
It is a high bond.
So I was going to see if you would consider lowering that. From what his mom told me, the RIP call says that the complaining witness doesn't want to testify, but says some sort of probation or something like that. But then
It's a familial case. I know how these cases, right?
The family's saying, well, no, the brother wants the case against him dismissed, right? So that tells me that there's not a conflict there. If, mom and brother want him home, I think that's a better environment. Obviously, he picked up this case, then he was living at the cousin because he couldn't be at the house. And obviously, cousin, no supervision, he's using cocaine, So I think he'd be better back with mom.
I know how these cases end up, and it's just, brothers fight. I get it. Sisters fight. I get it. And that's not my problem. My problem is the drug usage and how to stop it. Because you're only 19 and you repeatedly continue to use. How you're getting the money to buy cocaine at 19 is he working?
He was working for work, but when he got all this and got locked up, he
Right. Obviously, he's lost it now, but how are you getting the money? These are rhetorical questions you don't need to answer. How are you getting it? Where do you get the money? And more importantly, how do we get it to stop? That's the question that I have.
Video.
And that's what I'm grappling with now, Mr. Garcia. I want to let you out. I don't want to keep you in jail. But if I let you out, I know what's going to happen. So how do we prevent that from happening?
Is there any sort of county inpatient program, if he was granted a bond, that he could go to?
Yeah, I mean, we do. Is there a safe P or like YMAC, young men about change? Is that something that we can do? Can we look into that? Do you mind? Okay. I think that is probably, I think that we need to do, so what we have is we have evaluations. We have people to talk to him.
You get out of jail, but
Yeah.
if you can.
Sorry, we have people to evaluate him to see what the proper course of action is, like what kind of treatment program, whether there's something that we can do out in the free world where is it something that we would have to do while he's in custody? That depends on how the TRAS goes with him. So I think that that's probably the wisest thing that we need to do is set you up.
Right now,
What I'm going to do is I'm going to try to, can we do it again on Friday, you think? Do you mind? I tell them we won't do it anymore. We're the last one so that they don't get upset, you know? I want you to do a TRAS. This is an evaluation to see where we go from here. Be honest, because I'm going to get a copy of it and I'm going to read it. And I'm going to know if you're honest or not. And if you're not honest, I'm going to make you do it right over again.
Okay, sorry, Your Honor, what's a TRAS?
It's an evaluation to see what kind of program, if any, we should put you in so that the dope stops. Now, a lot of time, I mean, I shouldn't say a lot of time, you have to also want it to stop. If you don't want it to stop, it's not going to stop. And the problem is if you continue, one of two things are going to happen. You're either going to end up dead or you're going to end up in prison because your addiction is going to become so bad. Dope is very expensive. And people will do just about anything to get their hands on dope, including breaking into houses, breaking into cars. And what happens is you'll end up getting shot. You'll end up getting killed, or much worse. I mean, well, I guess nothing's worse than getting shot and killed, but you could end up in prison on a 25-year sentence, because you do something that you just can't dig yourself out of. Mr. Garcia, I'm trying to prevent that from happening.
Yes, sir, thank you.
Don't thank me.
I know, but I know.
Be honest and
I know.
make it work.
All right.
Did you graduate from high school?
No, but I'm working to get my GED.
Everybody tells me that. That's something else that we're going to do as well, because I'm going to make sure before all is said and done with us that you will have a high school diploma, because I will not do anything in this case until you have your high school diploma. You understand?
Sure.
And if I have to continue putting you in there, I'll do it in a heartbeat. So I'm going to set you up for a TRAS for Friday. We will get the results on Monday, and then that'll dictate where we go.
So reset for Monday or Tuesday?
Set it for Monday.
For Monday?
Monday.
We'll have the results?
I'm trying.
Okay, I'll roll them to Tuesday.
I can't force them to try to, I'm expediting it to try to get it done as fast as possible so he doesn't have to sit there and languish.
Okay.
If I let him out, I know what's going to happen. History dictates what's going to happen. So I don't want him to end up in prison or dead. And this is the best way that I think it can happen. Give me questions.
The only thing that I wanted to see is I'm able to get a bond or not, since we have to wait till Monday, I have to wait to look for that stuff.
Correct. I mean, his bond is at 15,002. But the problem is that if I let him out, I know what he's going to go do. He's not going to show up for a TRAS, or he's going to go and start partying again. I don't want that to happen. We did that. Do you work? When the cat's away, the mice will play. I mean, you have a life too. You can't keep eyes 24/7 on him. That's the problem. You got to work too. When you work, what do you think he's doing? If I had another method, I would. And We've tried. We tried that last time.
Judge, can we come back Monday, see where the TRAS is at, reconsider, and if you were to reconsider, obviously some sort of GPS monitor?
Let's see what the TRAS says and we'll go from there. I don't want to make any promises because
I understand.
I don't want them to get upset that I go back on any word. I don't know. I think the most important thing is we need to have the TRAS done. Mr. Garcia, please be honest, because if you are not, I will schedule you for another one and I'm not going to expedite it this time. The next TRAS, they're all set for August 12th. I'm expediting it now to help you get it done as fast as possible. But if you're not honest, I will not expedite the next one. Do you understand?
All
right. So Greg, let's set it to Monday and we'll go from there.
And then I need your son that's to call the DA.
And what is it?
She'll give you a card. He'll give you a card. Okay, thank you. I'll give you a card. Okay.
Victoria, what does your TRAS say?
Got it pointed to Miss Smith. Okay.
So she said she's not driving right now and didn't know if she would be able to do a no driving affidavit in a portable device.
Correct.
If that's possible.
Come up, Miss Smith. Why is she not driving? I guess we'll find out. Miss Smith, do you have a car?
Yes.
Okay, I'm gonna put an interlock on that car. Because so many people here tell me they're not gonna drive. And they drive anyways. I'm gonna pay for it for you, so there's nothing out of your pocket. But I will put an interlock on your car regardless. If you tell me you're not gonna drive, that's okay, but I will give you a portable device. But I absolutely want an interlock on that car, so I know whoever drives it, if they have alcohol in their system, it's not gonna turn on. It takes your picture every time you blow into it. Do you understand me?
Yes, sir.
So beware that if you try to fool us by having someone else blow into it, or you obstruct the view by looking outside the camera, it's just as good as blowing hot. Okay? So if you're not going to drive, that's okay, but I'm still going to put an interlock on it so I know it doesn't get driven.
I didn't drive here. I lived it here. So how do I go about doing that?
So what's going to happen now is we will give you a court order. Okay? You will get the portable device today, and then you're going to have to make an appointment to bring the car in to have the interlock put on, but someone else is going to have to drive it. Well, I mean, since I'm giving you a portable device, I'm okay with you driving it. You know, just I want the interlock on the car just in case, and I'll pay for everything so nothing comes out of your pocket. So there's no excuse.
So if she does get the interlock in the vehicle, you're saying that she also needs the portable device?
If she's telling me she's not going to drive, I want the portable, but I still want the interlock on the car to make sure that it doesn't get driven. Or if someone drives it, there's no alcohol on board.
And so why am I getting both? Like, so I get the portable one and then get the interlock on the car
I guess
and turn in the portable one? Or like
So typically what happens is when we put it on a car, you blow when you get in the car, but there's also a blow schedule that you have as well so that we know that you're not using alcohol. If you're not going to use the car and the car's just going to sit there, then we know you're never going to blow, right? So you could conceivably consume alcohol, we'd never know. So that's why I would give you a portable device so I know that you're not consuming, unless you want to continue to go out to the car and blow into it.
So if she is driving and using the vehicle with the interlock, she wouldn't need the portable.
Correct.
But if she's going to not drive, then she would need the portable.
You see what I mean? Right. So you tell me how you want it. I'm happy to do however you want it. Just talk with Josh and you let me know.
Wait, talk over here, Judge?
For sure. No. You guys can go. Huh? Hello? No. Okay. Docket. Okay, all right. I'll go now. All right. Yeah, I'll call them on the way. All right. Bye. Yeah, I gotta go get him. He's got a high fever and eye pain, so I gotta go get him. Damn it. Hey, can you hear me? So what do we do next? I'm gonna file that. It has to be rushed over to the sheriff's office.
Okay, so send a copy to the.
Huh? Had you want to, do you want Melissa to just email it to you or what? You can email it to Sylvia.
Yeah, I'll do it. Okay.
Judge, please stop calling me while I'm doing a live stream.
Got it. Okay.
You're not Fozzie.
Say it again. Yeah, he was in pre-release. All right, thanks. Ramona, I gotta go. Yeah, baby's sick. He has a high fever and eye pain. So, can we just go through the docket real quick? Who no shows?
Judge on Paige Brown, she called yesterday that she was she's in West Oaks and she won't be released until today.
His wife is a nurse and he's a judge. And he goes to get the sick kid. My ex had never once went to get the kids when they were sick, and I'm worked, and he didn't.
Your Honor, did party have a heads up?
Let me see real quick. I did. Here she is. Do you have Ms. Moss?
Yeah, she's back.
Great. Do you mind bringing her up?
We didn't need, I had text Luis just in case for Bosco, but did you? I don't know where they went.
I don't know. Okay, Ramona, who are you talking about? Hi, Irma.
Paige Brown, she called yesterday, but she went to be released today. I tried to call back to let her know when it comes to.
Okay, SFBF tomorrow. Okay,
Have you heard from Casanova or Calhoun?
I've not. So just hold on it for now, and then I'll call you in like an hour and a half.
Morales, on page as well.
Mr. Frausto, do you speak English?
I try, Your Honor. I try.
Right, toma asiento. We were waiting for, okay.
Okay.
Did she get the motion filed or not? Huh? So let's do this. I'm gonna roll to tomorrow, and then he's gonna be back here tomorrow. Paria, Day. Come on up, Miss Moss. Okay. Good morning, Miss Moss. So tell me about Aparia.
So Judge, this is the young lady I talked to you about last week. I've been speaking to her mom. She has 3 children. I don't have my notes with me since I'm on vacation. I think they're 9, 5, and 4. She has a great job at Jack in the Box. I think she's been in custody about 3 weeks. They said they'd hold the job open for her for about a month. So I need to get her out of there kind of within a week. To be able to go to work and then turn herself into Louisiana. You said that you would give her a bond. You just wanted her present to admonish her. You were wanting for us to agree to a bond, but we've spoken, and unfortunately, I don't think we can agree on an amount. Day is asking for $10,000. I'm asking for $1,000. If just as a reminder, the case out of Louisiana is an unauthorized use of a motor vehicle. It's one of those, and I hope I'm not getting the name of the company wrong because again, it's been a minute. I think it's like a U-Haul for keeping a vehicle past a certain amount of days. Her family's already in contact with the complainants. They're trying to get restitution because all they want is that, and then they'll tell the Louisiana DA's office to drop the charges. But like I told you last week, that takes a minute. But that's always what happens in all of these cases, essentially. Since it's not the most serious offense, and she already does have a $20,000 bond set on her felony case here, she's already having.
It's one thing after the other with Miss Moss. I mean, in 22, you have a felony deadly conduct. I got to imagine that she either shot at someone or had something with a weapon.
There's a gun, Judge.
What did she do? Allegedly. After that, you have a felony theft from an elderly person 3 months later. In July of this year, you pick up a failure to ID as a fugitive from justice. In February of this year, you pick up a felony injury to a child, and now you have a UUMV from Louisiana, and you want me to give you a bond?
Did you want the probable cause for them?
Yeah.
Officer responded to a weapons disturbance upon arrival. Officer in contact with the complainant witness who stated that while a basketball game turned into a physical disturbance, the 2 children assaulted minor RM, which was broken up by CW. A black female defendant, Moss, then arrived at the scene with a black-colored Springfield XDS pistol tucked into her waistband and accused CW of assaulting her 2 young children and placed her hand on her gun while stating, "I'll fucking shoot you, motherfucker, and you need to take your African asses back to Africa." Defendant Moss then called an unknown individual, telling them to pull up. A black male defendant, Hayward Trahan, then arrived a short time later and struck the complaining witness in the face with a closed fist, causing pain. Defendant Hayward Trahan and stated to complaining witness, "That's for fucking with my baby mama," and then left the scene in a white SUV. Officer conducted a photo lineup, and the defendant Hayward Trahan was ID'd by both complaining witness and witness.
So now what happened with the injury to a child case, please?
It has been reset to July 9th.
I know, but what happened is it, she's got 3 kids. Is this involving one of those 3 kids as well?
No, Judge, it seems to be the child of a neighbor. Officer dispatched to an assault and met with the complaining witness who advised the defendant came to her residence to fight after a disagreement at the neighborhood park. In the process, defendant grabbed complaining witness to a 6-year-old by the neck after a scratch. Officer observed the injury and believed that a reasonable person would be in pain. Officer also observed the juvenile to be visibly scared.
And you want me to give her a low bond, Paria?
I was just asking for a reasonable bond just to get her. Sorry, go ahead.
You're a dangerous person, man. My only concern, 2 things, right? Number 1, that you go to Louisiana, but more importantly, that my county, Harris County, is protected, right? You have shown over and over that your trigger temper gets the better of you and you end up in jail charged with a felony. And all these, it's not like these cases are from 5 years ago, 10 years ago. They're all fresh. They're still going on now. I don't know about giving you a bond, Miss Moss. You scare me. I know you're going to tell me it's little bunnies jumping in the woods, but when you get out there, you turn into a different person. I'm surprised, Day, that you were agreed to a bond in this case, really. I'm really surprised that you were.
Judge, I'm sorry to interrupt, but
It's okay.
we came last week. I can't remember if it was Thursday or Friday. I'm sorry. I think it was Friday. And we went over Miss Moss's case, and you specifically said that you would give her a bond and to put her on the docket. You just wanted to admonish her in person, which is why, I'll be honest,
I hadn't looked at her criminal history at that point.
Okay.
I didn't, and I guess,
'Cause I approached
you know, and there's my mistake for speaking
No,
without looking.
Yeah, because the thing is, that's why I reached out to him. And you can see, I don't have any cases on the docket this week. I'm on vacation with my family. So I only put her on because because you said there was a chance of her getting out of jail. Is just the only reason I put the case on the docket and had her come. So if you would at the very least agree to the bond that Day agree, if you're not inclined to give her a bond, and Day agreed to a $10,000 bond, would you at least set that? I'm not sure if the family can make it. If they can't, what they'll do is just post the felony bond to trigger her 14 days for Louisiana, which will at least hopefully get her there to be able to get out in time to go back to work. But since we already went through all this trouble and then the state has agreed to 10,000, I've already informed the family that you'd agreed, since that I was just going based on what you said, Judge, when we approached the first time with the prosecutors.
Just for Jay's part, I informed him when he came back that he had discussed possibly giving bond last week, and I think he was surprised as well. So that's probably the only reason he offered the 10K.
That's correct.
I guess, let me see what conditions the felony court has put on so that we know.
And that was the other thing I was going to tell Your Honor. Obviously, I know you're reading the PC for the felony case, but that's obviously being addressed in the felony court, and that judge has set a bond as they see fit, that's actually a pretty difficult court, the 174th. So if they've set a $20,000 bond just out of deference.
What judge is that in the 174th?
It's Hazel Jones, Your Honor. And she's, like I said, she's not one to give notoriously low bonds. I've practiced in her court before.
I agree. I agree
yeah.
with you on that. Okay.
I like the judge in the 184. I'm going to start getting more from her. She's really good.
And I just wanted to, just because it wasn't addressed before, I don't know if it's already been resolved, if party already resolved it separately, but I do show an out-of-county hold as well, Judge. I don't know.
There's another out-of-county hold too?
I didn't know about that. Let me double see if that pops up on my system. I didn't know about that. Hold on.
Okay. So, and I would say, I don't know. I know there is a hold. And so I guess that was a miscommunication on the emails back and forth. That's the one I was addressing after the felonies, is that I didn't know if she already intended to have a number set in the out of county, or if it was already if there was already a defense attorney there that was addressing it.
What's the other hold, Day?
That's the issue. I was trying to look it up the other day, and I don't know because I couldn't find it on the FBI number search or the NCIC search. But
it could be a capital murder case. I mean, how do I know?
It didn't flag. Let me run it one more time, Judge.
Yeah, hold on a second. Let me just run it also.
While I'm waiting, Ricardo,
Hey, Judge.
tell me.
Judge, I just need to speak with Amy about,
Hey, I gotta run. I have to go. So if you tell me who you have real quick.
Ms. Moss, can you step back so we can have Irma here for Mr. Fausto real quick?
If you can translate for Mr. Fausto to Tracy that he needs a scram on his ankle. That's it.
Okay. So Day, I'm sorry to interrupt. I'm looking at the holds. You may want to check with the clerks. I do not see an out-of-county hold. Now, I do see 2 out-of-state holds, one Jefferson Parish and one New Orleans Parish. I don't see 2 fugitive cases filed for you.
So the 071124, that it's on the left side on the CRT, it says OOC. So that's how I was looking at it, the out-of-county.
Well, you're saying my system shows differently. So
Okay.
I don't know what you're talking about.
Yeah.
But we needed Victoria in this situation.
want to check with the clerks, you can. I don't
I
see an
will.
out-of-county hold.
Yeah, I'll do that right now. I'll do that right now.
OOC.
Defense just says out of state.
I just see two out-of-state cases.
Agreed.
That's it. One out of Jefferson Parish and one out of New Orleans Parish.
I just emailed Melissa on the one I'm referring to.
Okay, where? What is that?
I like that.
If I'm reading it wrong, then I'm reading it wrong, but I just saw the OOC on the side of the 071124.
So she does have an out-of-county?
It's in out of county, but it hasn't been created.
Yeah, there's no information for us to see.
What is it?
Just as out of state. Like this is always.
There is an out-of-county case, but it just hasn't been processed yet.
Oh, okay.
I don't know, and it may be just too early yet. I just don't know.
Okay. I mean, and so that's why yesterday.
I would say at a minimum, let's wait till tomorrow to give you time, and then I can get Melissa time to look at what the out-of-county is. Because I don't know what it is. There's definitely a case there. It just, I don't know if it's been processed yet.
You think we'll know by tomorrow, Judge?
I hope. I don't know. I don't want to put my foot in my mouth again. I already did it once. Like I always do it.
Okay.
Contact somebody and figure it out.
Okay. She's going to look into it now, Paria.
Okay, so roll to tomorrow?
Yeah, let's do that.
Okay, no, thank you guys.
Poor Paria.
It's all right. That's okay. Bye.
We'll see you tomorrow, man.
Bye.
All right.
It's a bird feeder. Hummingbirds have been flying around her this whole time. It was lovely.
Ricardo. You're walking in here like you got some kind of swagger.
I don't got no swagger.
That's right. Swagger comes with this, comes with knowledge. That's swagger.
Yes, sir.
What have you done?
Trying to get to work.
What does that mean?
Trying to get to work. Trying to get my research so I can get to work.
I told you to enroll in GED classes.
This is full of ACD. Got orientation today. Can I look at my phone and show you what time?
Sure.
All the sound effects is not needed.
I'm breathing. I can breathe. It's my right.
If you give me attitude,
I don't got attitude, you judge. I'm just saying.
you're going to end up in.
Frustrated. I got a right to be frustrated. I've been here since 8:30. Finna be late. I just got my job actually 2 days ago. Finna be late on the first day. So.
Finna.
Before my time, we could have avoided this.
Finna be
court date.
late.
Yeah, he did. He also did. He also
And I've been
did.
trying to contact him for 4 days.
Thank you.
Today,
Thank you.
July
Thank
31st at
you.
5 p.m.
Welcome to Green.
I missed the 28th because I had something else to do, but I'm
Put your
going
hands
to.
down by your side.
It says registration in person, July 29th and 31, 8 a.m. or 5 p.m.
5 p.m. I missed 8 a.m.
Get church.
Huh? It's GET Church. It's an HCDE program.
This doesn't even have your name on it.
I already filled it out. It's in my email, but I don't have internet like that here. It's gonna take a lot to pull up. You don't think I did it?
No, I
Okay,
don't.
well, that's fine. I got the
So
email.
I do. Mr. Calhoun,
Yes, sir.
2 things. I don't like to play games.
I'm not playing no games with you.
You're coming in here with an attitude.
I have an attitude with you, sir. I'm just a little frustrated. I have a right to be frustrated as a human being. Just like you get frustrated with me when we tell you lies and think that you're stupid, I got the right to be frustrated. Because just like you want me to get right, that's what I'm trying to do for myself. Not for you, for myself and my daughter. But I have to sit up here until 11:30 when I'm supposed to be here at 8:30, from what my attorney told me.
How many times did you contact him?
He didn't contact me, not one time. He contacted me yesterday.
4 times, Judge. We tried to call
I'm
him.
talking to you.
We
Talking to
attempted
him.
contact 4 times, Your Honor. Despite his readings. On the 30th, we spoke to someone who says he's his wife.
No, that was my mother.
And on the 29th, we tried to reach out. There was no answer. So it was 2 times we tried. We spoke to his mother yesterday.
He never called my phone number, not once.
If you would have responded to him, gotten the proof to him.
Sir, I have other things that I have to do too as well. I have a whole daughter that I have to take care of. I have to work a job. I can't, my GED was going to come regardless if I had to see you or not. So if I had to come here to see you just to get a GED, I was going to get it regardless. I didn't need your help to get my GED, sir. That's what I want to do for myself. I don't need your help, Judge. With all due respect, I thank you for doing that because it's going to make me get it faster. But I was going to do that on my own already. I made a mistake. Yes, I'm back here again. It's just my 6th time seeing you in my life. Okay, understand that.
Mr. Calhoun, I'm going to bring you back here on Monday.
Okay, that's fine.
And I want to see the proof of enrollment with your name on it.
Go back outside and go get my email. I already filled out that. I already did that.
I will see you on Monday. My son is sick. He's got a high fever and his eye hurts. And I was supposed to get him about half an hour ago. So I'm leaving now to go get him so I can take him to the doctor. I will put you back on Monday. Come back, get a good night's sleep.
Plum.
Have a good attitude. We've been nothing but nice to you.
My attorney.
Don't interrupt the judge when he's talking. Just be
We're
quiet.
having a conversation.
Stop talking.
When you get into a pissing match with people with power, who's going to lose?
I listen to you.
How old are you?
I'm 20.
You're going to get it one day, Mr. Calhoun.
I am, and I'm going to be way richer than him.
Okay. I hope so. I really do.
You gotta hope.
You know,
You're going to see me.
you're 20. You don't even have a high school education, dude.
I know a lot of people that don't have
You
one.
need it.
No, I don't. But
Well,
yes, sir. Yes, sir.
You
Yes,
need
sir.
it with me.
Yes, sir.
Right.
You're right. Only because you said so, Judge, but I was going to.
So I will see you back here on Monday.
Yes, sir.
I want you to be nice.
Be nice.
Get a
to
good
who
night's
don't
sleep.
Respect me. I respect them.
If you interrupt me again, I'm going to put you in jail.
I have the other
Just don't.
half.
It's not hard to be nice, man. Really. You have some kind of aggression from somehow, somewhere, really. All we're trying to be nice and try to see you better yourself. That's all we're doing. Okay. So come back here Monday. I want the proof with your name on it. And then if so, we will pat you on your back and we'll send you on your way. Do you understand?
This will be the time to do that.
Yes or no?
Yes.
That smirk doesn't do you well.
But smirk. I'm not laughing.
Okay, come on. Get your brother. Get your brother. Mr. Yavarino. If he gives you attitude, Ramona, you let me know.
Rodriguez.
Okay.
He's here, yeah. So, he said, I think it's only case that we already used it today, and we got an initial offer of 4-year CDC. We're gonna come back to negotiate that. I think we're gonna resolve it pretty soon. We're set for September 25th.
You're set for sentencing when?
September 25th.
So he already pled.
No, sir. We just got the first offer of 4 years TDC.
You just got the first offer now? Oof. Okay, I mean, the case is 250 days. I can't, you know.
We need the hummingbirds back after that attitude.
So you said what day?
September 25th.
Okay.
I spoke to the DA here.
I know that they're gonna end up dismissing it. I mean, I know that, Frank.
Yeah.
Mr. Rodriguez, come up. Frank,
That's how I see it.
but if he doesn't take it that day, I'm setting this case for trial. I can't wait anymore, really. Mr. Rodriguez, it's time for you to make a decision on what to do. Your case is 245 days old. I will give you to the day that you have felony court. I will not wait anymore. If you don't take the time upstairs, because they've said that they will dismiss this case if you take the deal upstairs. Your case is 250 days. By then, it will be nearly 300 days. If nothing works out upstairs, that's okay with me, but I will set your case immediately for trial here, and I will give you a very short trial sentence. Do you understand?
Yes, sir.
That's it. We've run out of time. Okay, thanks, Frank. So Frank, do you want the same day or do you want the day after? Okay, yeah. Must appear.
Judge, Mr. Vasquez, apparently he's not in jail, so he's here on a required setting. All I have left is a phone number for his daughter that doesn't go through.
Is he?
I have no idea, Judge.
I'm gonna issue a warrant.
I would like to see if maybe you give me a chance and set it for bond forfeiture so I can try to see if I can, get a hold of his
How
daughter.
many chances do we have to give him?
Well, today was his required setting. So if you give him like I'm gone next week, Judge, so if you give him like a couple of weeks, I could try to send him a letter, try to get him to.
I guess we'll do
Smoke signals.
SFBF the 12th.
Perfect, Judge.
And then if he doesn't show up, then that's
Gotcha.
it.
Sounds fair. Thank you, Judge. Did you catch that?
Hey, Matt, come on.
Sarah, you're always there with the truth.
Judge? Trying to get out of here. Tell me.
Patience of Job.
No. Just, he's just trying to be a fool. It is what it is. You're 20 years old. You think you rule the world without a high school diploma. You know what I mean? Really. He's trying to push buttons. I'm not going to let it work. What you got?
It's a new case, new client, and he's charged with DWI.
Is it today? Tomorrow? Friday?
Next Tuesday.
Okay.
I have a CLE. We had Rick Court this morning. He went over there.
Oh, so you have him here now?
So I brought him in here now so I can get it reset. He already has electronic monitoring.
What's the cause number?
For you, Your Honor, it's 252-2061.
2064? 6. On Stevens?
Yes, sir.
Come up, Mr. Stevens.
Another Stephen.
That way.
Sir.
All right. You are James Robert Stevens.
Yes, sir.
Mr. Stevens, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Your Honor. On July 30th, 2024, officers observed a vehicle traveling on its rims, creating sparks behind it. The vehicle was weaving side to side, failing to maintain a single lane, causing other vehicles on the roadway to apply their brakes and change lanes in order to avoid being struck. Officers conducted a traffic stop. Upon approaching the vehicle, officers observed a box containing 2 full bottles of Sutter Home bottles in the rear passenger side floorboard and 2 empty Sutter Home bottles on the floorboard.
So he's drinking while he's driving?
Yes, Your Honor. Upon making contact with the driver, who is the defendant, the officer smelled a strong odor of alcoholic beverage emitting from his breath, red and glassy eyes, slow and slurred speech. Defendant admitted that he had had a few drinks, specifically some whiskey and 1.5 bottles of Sutter's Home wine. The defendant stated he had a 9mm handgun inside the center console, which was recovered. SFSTs were performed, 6 of 6 for the HGN, 5 of 8 for the walk and turn, and 2 of 4 for the one leg stand. The IC was read, breath was consented to, and the samples came to 0.242 and 0.246.
Okay, and then they found what? Cocaine or meth?
Cocaine, Judge.
Cocaine, Your Honor.
How much and where?
It was,
Less than a gram.
Okay. Where? On him or in his?
grams, Your Honor.
Okay. Mr. Stevens, I'm going to find that there's probable cause to go forward to the case. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
I am
Hi, Bill.
ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. And because of the cocaine, I'm telling you now, I'm going to test you like crazy. If I find that you're using anything, I will put you in jail, revoke your bond, and I'm going to make it sky high. Do you understand? If you repeatedly test positive for any kind of dope, I will put you in a rehab facility. The good news for you, it will be free. The bad news is it's a 9-month-long program, depending on how well you respond to treatment. Do you understand?
Sir.
No using whatsoever. If you have a problem, you better address it, because if you don't, I'm going to do it for you. And I have a lot of people in jail right now because they continue to use cocaine and they can't stop. Do you understand? You have a lawyer. I will waive your appearance, but it's your responsibility to stay in touch with Mr. Horak, and he will tell you when you have to come back to court. If Matt comes back to you and tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. No dope, no alcohol. Stay in touch with Mr. Horak, and if he tells you that your license gets suspended, you may not drive. All right? Okay. I'll have you go to Ramona, sign a reset. After that, you'll get with Tracy for your bond conditions, and after that, you guys are free to go. Thanks. For sure. Hey.
Good morning, Judge.
Hey.
Just approach from Mr. Contreras on today's docket, Judge. Sandra Contreras.
Yes.
She had a class and the rest of 1,100. She has about 500 to 600 now.
Has she given it to you?
Sorry, no, but she has, it's $1,100 total. And so we just want to
The
get.
problem is that when people get that kind of money and they have it saved up, they tend to spend it. So that's why we usually like them to give it to the lawyers in trust.
I don't, and I will say, if they're willing to issue a restitution receipt for like, say, $500.
They can't do that.
Well, and I know they don't
It
do.
has to be all in one. They will not piecemeal it like that. That's why we typically, when we have this, I usually ask the lawyers to keep it in trust or just hold it. And then when they get, because I'm telling you, my experience is they just spend it when they get it. Something happens. The car broke down. They need new tires.
Right. That's why. And I get it. If it's 1,100, I understand. Like if the restitution receipt says 1,100, they can't break it up into payments. But if the restitution receipt says
So
500.
let's do this. I'm going to set it. It's already 163 days old. I'll set you off 2 to 3 weeks. She's got to be here at the next setting. And if it's not all done, I don't know what I do.
Appreciate that.
Okay. Hey.
Hi, Judge.
Hi, Joaquin.
Question on Carlos Garcia. It's not on docket, Your Honor. It's something that's set on Friday, and I believe it's for a DPTI violation.
Okay. He's got to be here then.
Right. I've got a son's doctor appointment that was set almost a year ago that I cannot miss.
You want to bring him in the day before?
That would be tomorrow, and I'm out of county tomorrow. I'm in Galveston County.
Monday?
Monday I can do, yes.
Okay, so set the date with Ramona, and then if he fails to appear, I issue a warrant. Okay, yeah.
Okay, Eddie, bonus. How much do you want it?
What's the bond at now?
5,000.
Okay, it's 10,001.
10,000.
Yep.
And then
Yeah, I need to appoint someone as well. So let's do this. Yes, I need to go. So let's do this. No, I'm gonna roll into tomorrow. He's got to come back tomorrow. And then just have it ready for tomorrow morning. Come up.
Just sign it then.
I'm setting your case for tomorrow. You must be back here at 8:30 tomorrow morning. Do you understand?
Yes, sir.
If you fail to appear, I'm going to revoke your bond and make it. Oof. Do you understand?
Yes, sir.
Okay.
Can I just say,
I'm not going to, no. There's nothing that you can tell me at this point.
He doesn't need a reset.
Okay, first thing in the morning, 8:30, I'll see you at the door.
All right.
That was the entire docket. You guys went through the entire docket today. We never do that. Oh, well, I think we might have that one time he had the funeral too. But, oof. I'm going to use that all the time now. Oof. You don't do this, oof. Victoria, say that to Michael. If you don't bring food home, oof. I think it'll work. That'll put fear into him. Because oof could be anything. So right away, his mind's going to go to the worst. Victoria, you have work to do. You can't get here at 4:30 a.m. You need your sleep. I mean, the videos are up. No one has to come at 4:30 a.m. They could just watch it later. Most people actually do watch it later. I wonder what it would be like to like do a stream at like 2 p.m. like in the afternoon sometime. The thing about that is I was thinking about it, doing a stream every once in a while so that the other people can catch a live, but the chat the chat is almost more important than the live stream, and the chat won't be there. I mean, a lot of you will. Let's be honest. You guys are in court all day just like me, but a lot of the chat won't be there, so it won't be the same. It'll just be like court videos. Ugh. I mean, there'll be other people, but I don't know those other people yet. I should like do one a week though. I really should. There's no reason why I'm not. I should do like one a week at a normal time of day. Yeah, the chat, that's what's stopping me, the chat. Um, I mean, all you guys catch this on replay. That's great, but the chat here, it's like I don't know. I don't know. It's just not the same without the chat. Yeah. Yeah, well, Dave dear, that was freaking I still can't. Micah wants a short of that guy, and I just can't because I can't I can't. I can't do it. Someone else on the internet's gonna have to do that for you, Micah, because I don't know if I can. Oh, man. I know. I don't even know. I don't even know what's going on in the videos. You know what? Tomorrow I'm gonna put something stupidly boring up and let's see what happens. Maybe I already do. I don't even know. Hi, Karen. Oh, the videos are over, guys. If you're here just for videos, you can go now. Thank you so much for coming. I really appreciate it. I know, Michael. Everything. I got one. It's not as funny, Michael, but it's South Park. Completely South Park. This lawyer, he keeps saying, okay. Maybe I'll play that tomorrow. I don't know. Maybe I'll put it as a video, but it's not as funny as the staring guy. It's still funny though. Because every time he does that, I think of South Park, and I can't help it. It's funny. The court case itself is like boring. It's just this guy got busted dealing drugs, but the okay it gets me. I'm telling you, it gets me. Ah. Oh my gosh, that was so funny. I couldn't handle it. I just couldn't handle it. Yeah, you can replay with chat, but you can't talk. I know when people replay with chat and see the chat, they have things they want to say too. And they're like, "Oh man, I wish I would have said that. That would have been super funny." All right, I should do a stream. Okay, here's what I'll do. I got an idea. I will do like 30-minute stream at like 2 p.m. once a week. That will be really hard for me to do a 30-minute stream. I don't even know if I know how to. But other people should feel the family that we have here. It's not court videos. This isn't a place to come if you just want to see court videos. This is the wrong place. You're in the wrong spot. But don't hold your comments. Don't hold your comments. Comment all the time. Except if you're an extreme member, don't comment on the video that No comment on the video that I just posted for extreme members. No comments. I mean, really, what can you comment? I mean, no matter what you say, you're gonna get in trouble. Yeah, that's all you can comment on that is wow. You have questions, you have feelings, you have opinions, but nope, you gotta keep them all to yourself. All right. So membership, there's like tiers to membership. There's like I don't know what they are, and I know I made them, but it's like $1 a month, $5 a month, $10 a month. You can get a different type of membership to to this channel. And there's some people that pay extra. They pay like $5 a month, and one person, Fuzzy, pays $10 a month or whatever the highest is. So every once in a while, I throw a extreme video in there, and it's all videos I could never in a million years show regularly because no, it's because they're controversial, we'll say. So they get them. They get these extra bonus videos that, should probably not be should probably not be watched. But yeah, they pay they pay extra for extreme videos. None of them are terrible. They're not it's just fun. Yeah, it's just fun. Yeah, they're not monetized. None of my member videos are monetized. Never. I would never monetize a member video. That's just rude. I don't know, BI. I don't know. Listen, if you're gonna sign up for the extreme, you can't be like offensible, offendable. Don't don't come in there. Don't come in there and start saying, "Oh no, you shouldn't have posted that." Well, actually, no, you shouldn't have watched that. All I did was re-show something that happened in a court. No one goes to court for good reasons. Oh, yeah, you do. You do live in Hawaii. I can't even imagine. My niece just went to see Green Day in concert. The cheapest beer they had there was $18. The cheapest beer they had there was $18. Now, Andrea lives like that every day. Every day. I got bananas for what, like 39 cents a pound or whatever. She probably pays 39 bucks a pound in Hawaii. And they grow bananas there. I'm sure bananas would grow great in Hawaii, right? You're like right on that line. Yeah, yeah, that's the word. Offensivable. Don't listen, guys, if we are all just a little bit less offensivable, we would be way more happy. I'm serious. We don't have to get our panties in a bunch for half of the crap that we get our panties in a bunch about. Because, you know, really. I mean, really. Okay. All right. Listen. Thank you so much for coming out today. I really appreciate it. We got to see an entire Fleischer docket, which is just crazy. Um, hopefully his little boy Alex is okay. Right? Victoria said his boy Alex? Alex could be both, okay? My son's last girlfriend was Alex. I'm pretty sure she was a girl. To select a few, yeah, some people do join. You mean like some of you guys join? Yeah, some people do, but lots of people don't like public speaking. Mhm. Yeah. Yeah. Yes. That's right. I didn't see that, Shannon, but thank you for telling me. Okay, it's his son. So, yeah, hopefully little Alex feels better. Start all over, Linus? Do it again? It won't be as fun the second time. That's true. The good thing about going to a Green Day concert is you can't drive home drunk. You would need a second job to be able to drive home drunk from one of those concerts. I went to a Miami Dolphins versus Pittsburgh football game and paid $12 for a beer. 2 beers, so $24. I paid $24 for 2 beers, but I was at a football game. So, there was that. I know, though. Smashing Pumpkins opened for them. I didn't get to go, but does she? Oh, that would be so cool for Manning and Fleischer to sit there and just jam together. Well, no, wouldn't nope, that wouldn't work. Nope, we can't have that because they're both, like, in charge. So, who would pick the song? I mean, they would both be, like, you know, in charge. So, no, nope. We need an alpha and a beta? I don't know. My first concert, I think it was Motley Crue, I think. I'm pretty sure it was Motley Crue. I love me Motley Crue. I just love me some Motley Crue. Manic See, you don't have to. You don't have to get angry about the prices. They wanna sell their beers for $18, they can. You can drink at home. You can make your own. Hey, was it really? We're twinsies. Hey! I don't know anymore, Court. I'm tired. I have no idea if I'm still awake or not. Oh, man. But see, the chat goes so fast. It's like when I click a thing to put on screen, when I go to unclick it, chat moves, and then I put a different one on. That's what happens all the time. And you see me try to click around and try to get it off. Yeah, we're live. We are live. Not for much longer, though. We're about to be unalive, snoring, rolling and snoring. What is today? Thursday's my worst day at work. It's so slow. It's so dead. I don't do well just standing around. Nope. I'm gonna make shorts. I'm gonna make shorts all night tonight at work while people are waiting for their ranch. Oh, man, you guys have been to some awesome freaking concerts. Cool in the gang. Oh, my boys might come in tonight. I got this to the squash team. It's just a bunch of local men who play squash. I think that's what it is. Squash. I think it's sort of like racquetball. I don't know. I don't know what it is. Anyway, one's a pilot, one's a surgeon, one's a lawyer. Like these are just like all these big powerful men. They play squash and they come to see me every Thursday. However, their squash team went on the road and played in Barbados. So they've been in Barbados for like 2 months now. These men had just left their jobs and their wives and their kids and everything and just went to Barbados together for like 2 months. So they should be coming back. They might come in tonight. So I got to be there Thursday for my squash team, for my boys. Yeah, well, Donald, we're not going to be offendedable anymore. You're not allowed to be offended. If you want to be offended, go on someone else's stream, be offended. I know. What a reason. Like, I after David. Goal ball. Hold on. Everybody be quiet. There, I got it. No. I call everything sports ball though. Does that count? I did see an Olympic sport, handball. It was like soccer, but you use your hands, not your feet. And you could dribble like basketball, or you could just run with the ball, and then you throw it into the soccer net. That's pretty cool. Yeah, I didn't know that was an Olympic sport. Boy, if you would have told 18-year-old me handball was an Olympic sport. See, don't be so offensivable. Wait, I missed it. It moved there. Oh, the cat just fell. What's wrong with you? Walk much? All right, guys. Thank you so much for coming out. I appreciate it. I really, really do appreciate it. I'm gonna get some shorts done today. We're gonna think of a little short live for 2 p.m. As soon as Fleischer's stream is over, at some point, maybe not today. Probably won't be today because Fleischer's stream starts soon, and I have to get ready for courts. So I will see you guys in Fleischer's court, or I will see you tomorrow. Thank you so much for coming out. Thank you for the super chats. Thank you for the gifted memberships. Thank you for the memberships. Nope. Sorry, I'm missing someone. If you just give me 1 second, I'm gonna find him. I have to thank someone else. Christopher. I need my glasses for this. Christopher Davis. Thank you so much for the PayPal. I really, really, really appreciate it. Thank you. Bye, guys. Have a good day.